Welcome to the deep dive. We're here to unpack complex info fast.
And this is part of our ongoing series working through the Manual of Patent Examining Procedure, the MPP.
Yep, one section at a time. We want to make this stuff accessible for practitioners, patent bar students, really anyone curious about patent law.
Today we're diving into MPP Section 602. Now this sits within Chapter 600, which covers the parts, form, and content of application.
And Section 602, that's all about oaths and declarations. Super important stuff.
Absolutely fundamental. It's about establishing who the inventors are for a U.S. patent application. Think of it as the official inventor sign-off.
So our mission for this deep dive is to pull out the really critical nuggets from 602. We'll be looking at the rules like 37 CFR 1.63, 1.64, and the statutes behind them, like 35 USC 115.
Right. We want you to understand the legal requirements, the procedures, the must-knows.
Okay, let's dig in. So just to start at square one, what exactly is an oath or declaration in this context? Why does it matter so much?
Well, fundamentally, it's the inventor's formal statement. It confirms they believe they're the original inventor, or at least an original inventor.
Okay, inventor says, I invented this. What else?
And critically, that the application itself was made by them or authorized on their behalf. It's the legal bedrock for inventorship in the eyes of the USPTO.
So it connects the person to the paperwork.
Exactly. It's required by law, specifically 35 USC Section 115 sets the mandate. Then the USPTO rules, like those in 37 CFR, they spell out the how-to.
Statute is the what, rules are the how.
You got it. And it's not just ticking a box. It's about ensuring the accuracy, the integrity of who the government recognizes as the inventor.
Now, I understand there are options. It's not just the old-fashioned oath anymore, is it?
That's right. That's a key point in Section 602. Under the current rules, specifically 37 CFR 1.63, you can submit a declaration instead of an oath.
And that's pretty common now.
Oh, much more common. Way more common, yeah. It's generally simpler.
Okay, so what's the practical difference? Like, how do you actually do one versus the other?
Well, an oath, the traditional one, needs to be formally executed, sworn before someone authorized to administer oaths.
Like a notary public?
Exactly, a notary in the U.S., or if you're doing it abroad, maybe a U.S. consular officer. And the MPP points out you have to be careful. The location, the venue stated, has to match the notary's seal and jurisdiction. Little details matter there.
Sounds a bit more involved. And the declaration?
Much less formal in execution. No notary needed. You execute it under penalty of perjury.
Okay.
You just sign it. Can be done anywhere, in the U.S. or abroad. Just need the right wording, usually referencing 28 U.S.C. Section 1746. That flexibility is a huge advantage.
Makes sense. What about seals? Does it matter if the document has that official stamp or not?
Good question. The MPP mentions that. In some places, maybe certain states, or say for military personnel, seals might not be required for an official act. Even then, the document still needs to clearly show the title of the person certifying it. The USPTO needs to know who verified it, seal or no seal. Now, about those declarations, because there's no notary, the penalty of perjury part is really, really important.
That sounds serious. You mentioned 18 U.S.C. Section 1001 earlier.
Yes, exactly. Every single declaration must include specific warning language. It basically says that making willfully false statements is punishable under that federal law.
And 1001 is the law about lying to the government, right?
Precisely. We're talking significant penalties, potentially even prison time. It underscores that you absolutely have to be truthful in that declaration. It's not just form filling.
Wow. Okay. Definitely not just paperwork. How about submitting it? Do you need to mail in the original signed paper?
Thankfully, no. The USPTO is pretty modern there. They accept photocopies, faxes, electronic submissions like PDFs via EFS Web. That's standard practice.
Convenient.
Very. But, and this is a crucial practical tip from the MPPP source material, always keep the original signed document.
The actual paper with the ink. Why is that so important if they accept copies?
It's strategic. Think long term. Maybe years later, your patent gets challenged in court. Someone questions the inventorship. Being able to produce that original signed declaration, especially if the inventor isn't around anymore or can't be found, can be absolutely critical evidence. Don't throw it away. Keep it somewhere safe.
Okay, so we know what it is, the signing options. Now, who actually has to provide this oath or declaration?
The basic rule, simple. Every single person named as an inventor on the application. Each one needs to sign off.
Makes sense. They're the ones making the claim.
Yeah.
But what if someone can't sign? Maybe they're deceased or incapacitated or just unreachable. Does everything grind to a halt?
No. Thankfully, the system has a workaround for that. That's where something called a substitute statement comes in.
Substitute
Yeah,
statement.
and then MPP explains that someone else can provide the required statement if the actual inventor is, as you said, deceased, legally incapacitated, or can't be found or reached after diligent effort.
So the application can still move forward.
Exactly. It prevents the process from being completely blocked in those situations.
And there's a legal basis for this.
Oh, yes. It's laid out in 35 U.S.C. Section 115 Tandy. The MPEP gives an example. If an inventor just isn't legally capable of signing, another party, maybe an assignee or legal representative, can file that substitute statement under 115. It's a really important provision.
Right, and that ties back to something we see elsewhere in the MPP, doesn't it? How the USPTO sometimes defines applicant more broadly than just the inventor.
Precisely. The applicant can be the inventor or an assignee or someone with a significant ownership interest. Allowing substitute statements fits right in with that, acknowledging that others might need to act for the inventor sometimes. And speaking of assignees, MPEP Section 602 actually mentions a couple ways they interact with this process and even ways to make things a bit smoother.
Okay, how do assignees fit into the oath or declaration picture?
Well, first, there's a neat efficiency tip. The rules actually allow you to combine the inventor's declaration into the assignment document itself.
Ah, so the paper that transfers ownership can also include the inventor's statement.
Exactly. If the invention is being assigned anyway, like usually happens with employees, you can potentially handle both requirements in one go. Streamlines the paperwork.
That does sound efficient. What else?
Well, it relates more broadly to who controls the application. Remember, under rules like 37 CFR 3.71, the assignee of the entire interest, or all the partial owners together, can take control and prosecute the application.
Right. They drive the process.
So while the inventor signs the statement about inventing, the assignee might be the one actually filing that declaration and managing the whole case. Their role is crucial.
And isn't there something specific about assignees signing for reissue applications?
Yes, good catch. That's a specific carve-out mentioned in the source material. An assignee of the entire interest can sign the oath or declaration for a reissue application.
But there was a catch, right?
Big catch. Only if the reissue application is not broadening the scope of the original patent's claims. If you're trying to get broader claims in reissue, the inventor still needs to be involved in the declaration. So it's a limited exception for corrective, non-broadening reissues.
Okay, let's shift gears slightly. What happens if you mess up? You file the application, but maybe you forget the oath or declaration or the substitute statement.
Right, procedural hiccups. The MPE lays out how the USPTO handles that. It depends a bit on what else is missing in the filing date, especially around that September 16, 2012 date when rules changed.
So for applications filed since then?
Okay, so for an application under 37 CFR 1.53b, filed on or after that date, if you file without the oath declaration and you're also missing things like the filing fee or the surcharge, or you haven't provided inventor info via signed application data sheet, ADS.
Lots missing there.
Yeah, if it's that incomplete, the USPTO will issue a notice to file missing parts.
Sounds like a warning shot.
It is. You usually get 2 months from the date of that notice to provide everything, the oath or ADS, the fees, etc. If you don't fix it all within that window, the application typically goes abandoned.
Ouch. Okay, but what if you paid your fees, you filed a signed ADS listing the inventors, you just forgot the actual declaration document itself?
Slightly different scenario. If the only thing missing is the oath or declaration itself, but the fees and signed ADS are there, the office might just send an informational notice.
More like a reminder.
Kind of, yeah. It might not trigger that strict 2-month abandonment clock just for the missing declaration if the inventor info and money are already in.
But you still need to submit it eventually, right? You can't just ignore it.
Oh, absolutely not. The MPEP is crystal clear. No matter how it plays out initially, that required oath, declaration, or substitute statement must be filed before the patent can be granted. It has to be submitted no later than the date you pay the issue fee, period. No declaration, no patent. But here's some good news. Making an error or having an omission initially doesn't automatically kill your chances.
That's reassuring. So mistakes in the declaration can be fixed.
Yes, definitely. MPP Section 602 explicitly states that declarations can be corrected or supplemented later if necessary. And a really important point from the source material is that failing to get it perfect right out of the gate doesn't make a patent unenforceable down the line.
As long as
you fix the deficiency properly. This connects to other correction procedures in the MPP, like correcting the name's inventors in a pending application, that's 37 CFR 1.48a, or even fixing inventorship in an already issued patent under 35 U.S.C. 256.
Okay.
Those correction processes often involve filing a new or corrected inventor statement. The key requirement there is usually that the original error wasn't made with any deceptive intention, so honest mistakes can generally be remedied.
Okay, so boiling it all down, what's the big picture takeaway from MPPP Section 602 for someone dealing with patents?
Well, it's the rule book for how you formally prove inventorship. It spells out the mechanisms, oaths, declarations, substitute statements, and the formats the USPTO accepts to get that vital inventor information officially recorded.
So understanding these details like, declaration versus oath, the weight of that perjury warning, who signs when, how to fix mistakes, it's really fundamental to navigating the patent process correctly. It's the foundation of the inventor's claim.
Absolutely. And diving into this section, it really highlights how detailed the procedural side of the patent system is. It makes you think, doesn't it?
Yeah.
How does the system try to balance these sometimes quite strict formal requirements for identifying inventors against the practical need for flexibility and ways to correct genuine errors later on? It's a tricky balance.
It really is. A special thank you now to Mike Shepard, the creative director behind this whole audio series.
And just the necessary reminder, this summary was put together using AI tools like ChatGPT and NotebookLM. It might have errors or leave things out. It's meant for educational and informational purposes only. It's definitely not legal advice or a substitute for formal instruction.
Right. For the official word, always consult the actual MPP, talk to a qualified instructor, or get advice from a registered patent practitioner.
Definitely.
Thanks for diving deep with us today. We'll see you next time.